This is the Know Your Law series by Barefoot Law, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org. This is the Barefoot Law webinar on the process of buying land.
So first of all, a land agreement is in principle a contract, so it must conform to the elements of a valid contract. First of all, the intending vendor and the intending buyer must be legally capable of contracting. It basically means if you're an individual, you should be an adult. And then if you're a company, you must be incorporated under the Companies Act. Yes. And then you should not be insane if you're an individual. You should be of sound mind, things like that. Yes. Secondly, there must be an offer to sell the land and the buyer should accept. Okay? And then there must be consideration, which is basically the money, the value in exchange of the land. Is it monetary? Is it by gift? Because sometimes it's by gift. Yeah. Not necessarily money all the time. And then another tenet of a good sale of land agreement is there must be clauses indicating that the vendor has submitted those documents we've talked about in the due diligence, such as passport photos, and that clause should be included. And then there should be a clause on when vacant possession should be taken, because sometimes the land you intend to buy has squatters. So there should be clauses indicating when vacant possession will be taken, if compensation is going to be made and by who. And in most cases, it is the person selling the land who compensates the squatters on the land. Then another key issue is sometimes you're contracting with people who don't necessarily know English. They are more fluent in their local languages. So it is important in your sale of land agreement to have what they call a certificate of translation signed by a translator. That is very key. Because under the law, if you've contracted with someone and they come up and say, I didn't understand the terms of the contract, I don't know English, and there's no certificate of translation, then the transaction can be nullified on those grounds. So it's incumbent on parties who are contracting. If you're dealing with, say, an old Jaja who does not know English, you get a knows Luganda, get someone who is fluent in Luganda, both Luganda and English, to sign a certificate of translation in the sale of land agreement. That is very key. Many people forget that, but it's very key. Then, of course, when it comes to transfer clause is also very important. When will transfer take effect? Usually it's upon, of course, completion of the consideration, the completion of the purchase price, and also indicate the spouse. The spouse should also sign on that transfer, that sale of land agreement, that they've actually consented to the sale of land transaction. And then also the execution bit. When it comes to execution, if you're dealing, say, with a company, there are modalities on how companies sign. You don't just, put receptionist to sign. No. It's directors who have to sign in the presence of maybe another director or a secretary, or the seal can be affixed in the presence of two directors. So that's basically it. Those are the details between the buyer and the vendor on how much and in the mode of payment. But the key thing is to look out for things of vacant possession, certificate of translation, and basically parties being able to legally enter into a contract. Yeah.
Very many measures have been put in place to detect fraud and also prevent the same. When you look at the new certificates of title, the DCTs, the duplicate certificates of title, they have barcodes. That's a measure to detect fraud. Zonal offices have been spread all over the country to make them accessible. That's also a measure to bring services closer to the common people. We have opened up one-stop centers. They have been opened up by the ministry. So very many measures have been put in place. But it's incumbent upon a person to take their time, do the necessary diligence, because it's very, very expensive to recover land. It's very expensive to recover money. But it's very simple for you to take your time, do the necessary diligence, and do come up with a... And the transaction is good, for lack of a better word, such that you don't suffer recovering money, recovering land, etc., etc. But we have also got some scenarios where, say, fraudsters have created a title over another person's title. Ministry of Lands, there are remedies in the law, like cancellation of certificates of title. Like, for example, if something is strictly forbidden by the law, someone uses forged letters of administration to acquire registration. Someone forges a DCT, it bears forged signatures of registrars of titles. Such titles can be cancelled upon a person complaining to the Office of the Commissioner on Land Registration. The process entails someone complaining, the office issues a notice of intention to effect changes in the register, a public hearing is conducted, because the right to be heard is constitutional and irrevocable. Even if someone created a title over another, you must accord him the right to be heard before taking a decision whether to rectify the register by cancellation or not. So those are some of the measures. But for me, I always take it back to the community, to the people, to do the necessary diligence. It's not true that fraud is fabricated in land office. Because if you do your diligence, you will uncover everything and you will end up not entering into a certain transaction. So people should always do the necessary diligence. If you can't, engage services of a lawyer. It will save you some money. Rather than being in a tedious litigation process, criminal proceedings, etc., etc. Yes, that's it.
And then I've seen people put on their land, this land is not for sale. Can that also protect you?
Registration-wise, that can't protect you. You know, at land registration, we deal with the land register. And the entries on the certificate of title are limited. My colleague Doreen and they know, because there are three parts. There's what we call the description part. It describes the land. We don't make any entry there. You have what we call the proprietorship part. The only entry you make there is that the land has been transferred from Gertrude to Babu Hakim. Then the last is the encumbrance page, where we put mortgages, caveats, court orders, etc., etc. So we cannot make that entry on the register. But it's uncovered by due diligence. You going to the ground and say, hey, there is a caveat emptor. This land is not for sale. Due diligence, visiting the ground can unearth that, and it comes to your knowledge.
Now that you mentioned caveat, what is a caveat?
A caveat is a temporary relief that bars a registrar of titles from making any entry on the register without notifying the person who has lodged a caveat. A caveat is statutory. It's an encumbrance. Someone puts a bar on the land register, it's registrable on the register, that notifies the registrar of titles not to make any entry on the register book affecting their interest without notifying them. You know, I don't want to sound legalistic, such that the people watching us can understand.
In that same spirit, the word encumbrance has been mentioned so many times. And even I, that I'm sitting here, I keep wondering, my dictionary, does not connect.
An encumbrance is any bar to effecting an entry on the register book. Like, for example, if you lodge a caveat as an encumbrance, a registrar of titles cannot effect a transfer on that title. If you lodge a mortgage and a registrar of titles transfers that land, this person in whose favor a transfer has been effected is bound by this encumbrance. It's a charge that affects land. It's a charge that affects land. And there are quite a number. There is a caveat, a mortgage, a government charge, a court
Court
order,
order.
among others. Yes. But the most important one that the people watching us should know is a caveat. Now, for example, we have got instances where Doreen has a title at her place. Upon conducting a search at the registry, she finds out that a transfer has been effected. In order to avoid third-party rights
Subsequent.
from being created, you lodge a caveat, notifying the registrar that no transaction should be registered on this title without notifying me. That's it.
So we've now mentioned the due diligence. Now I'm at the point of paying. I manage, I get the money, I pay, but then let me say I have only half of the money and I cannot pay the rest. What do I do at that point?
First of all, when you're buying land, or that whole thing of getting land, it's an agreement. It's a contractual basis. It's at the contractual basis. So that means that both parties are bound. They have certain obligations. We have the seller, we have the buyer. As the seller, you must make sure that you transfer the land to the buyer. The possession, you must part with the possession. You must make sure that the land has no encumbrances or burdens or claims. But those are other words for that word encumbrance. Yes, so that is your obligation. Even the buyer, on the other hand, you must ensure that you are buying. You must pay consideration. You must pay the money. This land is not for free unless it is indicated that I'm giving it to you for free. So we all must understand our obligations. So, and let's try to be practical here. Sometimes people are not selling land for fun. They have an issue. I have a patient. So, and the only remedy in Africa or in Uganda is I have some land. Let me cut some portion and I sell. So I'm selling it to you. I want the money to use it for something. So if I'm going to give you I'm going to sell the land and you made part payment about it, what about the other balance? So now, of course, and in law, like I said, so the moment the seller you enter into an agreement to sell the land to the buyer, that means that for you only concern should be the money. The possession and the title must pass to the buyer, but that also the possession should depend on the agreement. When should possession pass? Should it be after all the payment or before? That is something that you could agree on with the buyer. However, that said, so that means, and if we are to follow that principle, that means that you, the buyer, if the other person has failed to pay, it means that you have to push the person to give you the money. The avenues are there. You cannot say, but how? I've tried to tell him, he has refused, he's crying, and of course everyone cries. We don't have money. But then you can use the LC. Of course, you can you can inform them. We are trying to be less formal here. So I could tell you, I could give you a call, trade him, pep up the balance. If that doesn't help, I could go to the LC1, reach out to the LC1. LC1s are very important people in our society. Like, you should not avoid them. Let the police is your friend, but let the LC1 also be your friend, because that is where most legal issues start from. You might reach court and they'll ask you, did you go to the LC1? You get it? So you could go to the LC1 and engage them so that they could notify the other person. And they probably the conversation is had and an agreement is made. But if that is done and nothing, the buyer is not coming through, he's not able to pay the money. Practically, let's go practically. So in this case, the buyer, in this case, and I think with the consent, because I say that the buyer in this case, this is not your land anymore. It is for the other person. The seller, this is not your land anymore. It's for the buyer. So that means that you could agree that you get another buyer. The one who has money. For you don't have money, let's get someone else who has money and we sell. So your business will be the price that you paid, can it be refunded? You, the buyer, the first buyer, the price that you paid, it can be refunded to you. Even me, the seller, since I had some balance, you give me my balance and we part in peace. But if that has failed really and you leave the seller with no option because they're entitled to this land, this was their land, they could as well get another buyer for the land and follow the same process. Invite the LC ones, let them be part of this whole process, please. You don't want to do this behind the curtains, and tomorrow when you open the curtains, you want to be heard, but we didn't know what was happening behind. Yes. So guys, please involve the LC ones. The seller also in this case can resell the land to someone else, pay the buyer the money that was paid to him, and also he obtains his balance. So that is the best way we can go about it practically. We must understand each other. I sold the land, I need the money. Even you, I understand you don't have money, but I also need it. So the best way is to get someone else, and then that's how it can be resolved. Thank you.
But I think what goes on here is the fact that this is an agreement, and we should not. What do they say? What's that Uganda word? Tetwa ukanya. Tetwa ukanya. Yeah, surely. Let's not let land separate us like this. It's an agreement. Let us sit down and talk. And I think that's where this whole conversation just leads to. Let us have a conversation. It's an agreement. You agree. You say this is what I'm giving. This is what this is what I'm taking. Let it be an agreement. Yeah. So if I may just go back to Doreen. Doreen, yes, I've had land title, people mention title yange, bane title tenava, your title. How important is this title thing in land?
First of all, under the law, a title is conclusive evidence of ownership of land. Of course, subject to other exceptions, which I'll go into later on. When you don't have a title, you have what they call an equitable interest. It's also an interest in land, but it's always advisable for someone to proceed and have their interest registered. Under the law, we have what you call indefeasibility of title. In other words, a title cannot be revoked, cannot be altered, except for cases of maybe fraud or other instances which I'm not going to go into because that is so much legalese. But a title is very important because it is evidence against the whole world. It's a public document. It's a public document to the effect that Doreen owns this land or Hakim owns this land. So it's important for one to register their interest and have it on public records that the whole world knows that this is Doreen's document or Hakim's document. Secondly, when you register your land, you have advantages of, say, getting loans from banks. No one wants to deal with bivanjas, really. Usually people want to offer mortgages based on certificates of title. So titles have various advantages. Also, in the event that maybe you have land disputes, it's easier to resolve a dispute when you have a certificate of title, as opposed to having an equitable interest in land. Yes.
So that means if you have a title, you are indispensable at this point. You are the owner of the land.
You are the owner of the land, yes. Of course, except if maybe it was acquired through fraud.
Yeah.
Or if you have defaulted as a mortgagee with a mortgager who is a bank. I mean, if you are a mortgager and you defaulted against the mortgagee who is the bank, there the bank's priority takes. The bank's interest takes priority. Yeah. And of course, if you're a bona fide purchaser for value, take priority. Yeah.
All right.
Hello. Welcome to the Know Your Law series, where Barefoot Law answers frequently asked questions on the law. Do you have employment issues? Questions about family law, criminal law, land transactions? The answers are right here on the Know Your Law series.